So you signed a contract. It feels pretty set in stone, right? Like a binding promise. But what happens when things change? When both people just want to move on? Well, in this explainer, we're going to break down exactly how you can legally end or even change an agreement by mutual consent, all under the Indian Contract Act of 1872.
Okay, let's just start right here. This single sentence from Section 62 is, well, it's the whole game. It's the legal foundation for everything we're about to talk about. It's what gives people the power to adapt and change their minds, as long, and this is the key part, as long as they do it together.
So here's our roadmap. We'll kick things off with the core legal principles. Then we'll unpack each of the key methods one by one with some really clear examples. And finally, we'll wrap it all up by talking about why this stuff is so incredibly important in the real world of business. All right, first things first, let's build that foundation. We're going to explore the fundamental powers baked right into the Indian Contract Act that let people mutually change or even just walk away from their agreements. The big idea here is that the law itself gives you a formal, structured way to adapt. This isn't some kind of loophole. It's actually a feature. It's built right in, designed for flexibility, and it allows contracts to evolve when situations change, often without ever having to step foot in a courtroom.
So our first major method for ending a contract is called novation. I want you to think of this as more than just a simple edit. It's like hitting a complete reset button and starting fresh with a brand new deal. The key concept to grab onto with novation is complete replacement. The old contract isn't just tweaked, it's completely wiped out. A brand new one takes its place, and that makes the original agreement totally obsolete. This example is perfect because it shows novation with a change of parties. So why would this happen? Well, maybe R is a more secure debtor for Q, and P just needs a clean way out. The absolute key, though, is that P, Q, and R all have to agree. Once they do, P is completely off the hook. That old debt is gone, replaced by a totally new obligation between R and Q. But hold on, novation isn't some casual thing. It's got some really strict conditions. First, you have to create a new, legally solid contract. Second, everyone involved, old parties, new parties, all of them, has to consent. And third, and this is absolutely crucial, it has to happen before the original deal is broken. And this isn't just theory. This legal precedent goes back over 100 years. The court in this case made it crystal clear. Timing is everything. Once a contract has been breached, the whole dynamic changes, and you can't just use novation to swap in a new agreement anymore. Okay, next up, let's untangle two concepts that sound a little alike but are actually totally different. Are you just changing a few details, or are you tearing up the whole agreement? That's the core difference between alteration and rescission. So, with an alteration, the original contract actually survives. It just looks a little different. Think of it like editing a Word doc with track changes on. The main agreement is still there, but a really important part, like the price or the delivery date, has been changed. And you guessed it, it needs everyone to agree. And this isn't some old-timey rule either. A more recent Supreme Court case really hammered this point home. One person can't just decide to change the core terms of a deal on their own. Any significant change is totally invalid unless everybody's on board. Now, rescission is the complete opposite. It's the big undo button. No new contract gets made, the parties just agree to walk away, and, according to Section 64, they usually have to give back any benefits they've already received. It's all about making it like the contract never even existed. This table really lays out the critical differences. Look, it basically comes down to the parties involved and what happens to the original contract. Novation can bring new people into the deal, and it completely kills the old agreement. Alteration, on the other hand, keeps the original players and just modifies the existing playbook. That's the main distinction you need to remember. All right, let's cover 3 more really practical ways to discharge a contract by agreement. Each one of these serves a very unique and, frankly, very flexible function when you're managing your duties under a contract. So, on the left, we have remission. This is all about the substance. It's when you agree to accept less than you were originally owed, just like Peter taking 6 lakh rupees instead of the full 10 lakh rupees. On the right, we have waiver. This is about your rights and conditions. A party just voluntarily gives up their right to enforce a specific rule, like a deadline. Both are really powerful acts of consent. Now, this next one, merger, is a really fascinating legal idea. It's basically when a smaller right gets absorbed or kind of swallowed up by a bigger, more powerful right. And when that happens, the contract that created that smaller right just becomes pointless, and it disappears. And this example makes the idea of merger click into place instantly. It's so clear.
You can't be a tenant in a house that you own. It just doesn't make sense. The second you get the ownership, that's the superior right, your lease agreement, the inferior right, is automatically gone. It just merges into your new status as the owner.
So we've gone through all these legal mechanisms, novation, rescission, merger, and the rest. But why does any of this really matter out there in the real world? Let's take a look at the actual benefits. At the end of the day, these aren't just abstract legal ideas for lawyers to argue about. They are practical, real-world tools. They're designed to make agreements actually work better. They give you the flexibility to adapt, to keep business relationships intact, and to avoid the incredible cost and stress of a legal fight. And that leaves us with one final thought. And it's really a question for you. Now that you understand these tools, think about a past disagreement, maybe a contract that went sour. Could a clear-headed novation, or a simple alteration, or even just a waiver, could it have stopped the problem before it even started? Because understanding these options is always the first step to using them effectively.